Hello everyone, welcome to the ASA and CAPS webinar for chiropractors. My name is James, I'm from the digital comms team, and today we're here to run over some of the rules that are likely to affect chiropractors, as well as answer some questions which have been kindly submitted by members of the British Chiropractic Association. Now, due to time constraints and the complexity of the topic at hand, we won't actually be able to answer questions live. But if there is anything that you'd like more information on, feel free to post a question or a comment, and we'll likely follow up with an FAQ in the coming weeks. Today, I'm joined by Janet Taylor from the Copy Advice team in the Committee of Advertising Practice. Janet, hello.
Hello.
So tell us a little bit about what we're going to talk about today.
Right. Hi, James. Hi, everyone, and thanks for listening today. I'm going to start with kind of like a super quick overview of the ASA and CAPS system, just in case you're not familiar with it. Essentially, we've got the CAP, which is the Committee of Advertising Practice. They write the advertising rules which advertisers are required to follow. CAP also provides advice and training, such as bespoke presentations and this webinar, on how those rules apply to specific types of claim or how they're likely to apply to specific sectors. Then you've got the ASA, which is the Advertising Standards Authority, and that's the one that you're probably more familiar with. And the ASA administers the advertising rules and decides whether the rules have been met or whether they've been broken. There are two codes of practice. We've got the broadcast code, which deals only with live TV and radio. But today we're going to be concentrating on the non-broadcast code, otherwise known as the CAP code, because this is the one that's actually going to be most relevant to chiropractors.
Okay, and does that mean that chiropractors need to worry about their ads?
No, not at all. First thing first is the fact that there's no need to worry. The chances are that no one's going to complain about your advertising. But having said that, we think it is good practice to make sure you understand what the rules are and that you're confident you comply with them, just in case someone does complain. But if someone does complain and the ASA contacts you, then again, don't panic. The ASA will explain what you need to do and will guide you through the entire process. And actually, in most cases, complaints can be resolved informally, simply by working with the ASA to remove any problematic claims that you might have.
Are there any specific rules that the chiropractors need to be aware of?
Yep, the most relevant rule is here on your screen at the moment, which is rule 12.1. So it might be the case there's many parts of the code that are going to apply to ads for services offered by chiropractors, but this is the most significant rule, and it relates to issues of misleading advertising. So essentially, all advertisers, including chiropractors, are responsible for making sure that objective claims are supported by evidence. It kind of stands to reason that if a claim is not supported by evidence, then that claim is probably going to be misleading.
Does this mean that individual chiropractors need to hold evidence for every single treatment claim? Surely it's understood that they can treat lots of medical conditions. After all, they are trained to do it and regulated by the GCC.
Well, over the last 10 years, the ASA and CAP have on various occasions worked with the GCC and trade bodies like the British Chiropractic Association and the Scottish Chiropractic Association in order to try and establish where there is evidence of efficacy for treatment claims of specific conditions using techniques that chiropractors often use. This has resulted in creating what is essentially a list of conditions which the ASA and CAP accepts in ads by chiropractors without those individual chiropractors having to hold the evidence themselves. The work that the ASA and CAP does with those who support chiropractors, like the BCA and the GCC, is something that's ongoing. And in fact, the ASA and CAP published some new guidance at the tail end of last year based on new evidence that had been submitted to us. This work resulted in us accepting there was actually evidence to support claims to treat sciatica, along with some minor sports injuries. But unfortunately, the jury is still out when it comes to claims to treat whiplash. So you're going to need to have evidence to support these type of claims. This guidance also looked at the issue of making claims to treat conditions that are specific to babies and pregnant women, because no specific evidence was made available to consider in relation to those particular type of patient group. So irrespective of treating specific conditions may be widespread amongst chiropractors, you're still going to need evidence to support those type of claims because we just haven't seen it yet.
I see. So does that mean that any claim that are not listed are prohibited? Does it mean you can't reference the fact chiropractors even treat babies and pregnant women, for example?
No, not at all. This is actually quite a common misconception. You can refer to the fact that you treat pregnant women and babies. You just need to avoid making claims that are specific to that patient group like, for example, colic in babies or pelvic pain in pregnant women, unless, of course, you hold evidence to support those claims. It's the same with any other treatment claim that might not appear on the approved list. Essentially, you just need to make sure you hold evidence to support the claims before you make them. This is kind of coming back to the rule we talked about earlier, which is Rule 12.1.
Cool. Chiropractors have asked in the questions submitted ahead of time if they're being restricted to only referencing treatments in relation to research containing the term chiropractic, and why there's a difference between what physiotherapists and osteopaths are allowed to say in advertising materials.
Right, well, the evidence that's been submitted over the years has been quite varied. Some of it has specifically referenced the term chiropractic, but others have used kind of more generic terms to describe the manual manipulation techniques used in the studies. So it's not always the case that we'll only look at evidence that specifically uses the term chiropractic. But of course, we will have to look at evidence that kind of uses techniques that chiropractors may use. We agree it may be the case that evidence submitted to CAP or the ASA could potentially also support the same claims being made in relation to other types of therapy that uses the same techniques. But essentially, it's not for the ASA to cross-apply the evidence it receives. It comes down to the principle that advertisers are responsible themselves for holding the evidence to support the claims being made about their own advertising and their own techniques. The fact that over the years, those representing chiropractors, osteopaths, and physiotherapists might have submitted different evidence, they might have submitted different arguments and presented it in different ways, and maybe kind of made a more persuasive argument why a particular condition should be referenced in relation to that particular therapy.
I see. So if you're making the claim, you need to have the evidence.
Essentially, yes. Yeah.
So what kind of evidence do chiropractors themselves actually need to hold?
The ASA is likely to expect to see clinical trial evidence, most likely in the form of randomized controlled trials. This is the trial standard the ASA applies to all advertisers making objective health or beauty claims. So chiropractors are not singled out in this respect. We do appreciate that some techniques or treatments that chiropractors use involve a multimodal approach. And if you're making claims to treat certain conditions using this multimodal approach, then you're going to need to hold the relevant evidence. If you don't have this RCT evidence, but do hold other types of robust clinical evidence, there's still a chance that it might be acceptable. But essentially, that would be for something for you to discuss with the ASA in the event of a complaint.
And does this position apply to individuals who offer treatments on animals?
In copy advice, yeah, we do occasionally see claims about chiropractors offering some services for animals, and the same rules apply on needing to have evidence. We haven't seen any evidence so far, but that doesn't necessarily mean that it doesn't exist. Essentially, if you do offer these services for animals and don't have any clinical evidence, it's perhaps safest to restrict claims to saying that you can help animals relax or something quite similar to that.
Okay. Another common one that we've been asked to shed some light on what the position is on using the Doctor of Chiropractic courtesy title in advertising.
Right, okay. It just so happens that the ASA recently ruled on a case where a chiropractor used kind of various versions of the courtesy title, and this has created basically a precedent which is likely to apply across the board to other advertisers also using the courtesy title in the advertising. The basics of the position is that you can use the title in advertising provided it does not mislead. So we need to look at this from the perspective of a consumer seeing the ad. So they're likely to assume that someone who uses the doctor title is a medical doctor, like a GP, or someone holds a general medical qualification. So if you don't hold a general medical qualification, any claims that suggest you do would, of course, be misleading. The very first principle is if you're going to use the word doctor in your title, you're going to need to immediately qualify it with the actual courtesy title you're allowed to use. We understand that the full courtesy title is Doctor of Chiropractic, but that's sometimes abbreviated to DC or DOC. And the ASA has ruled that DC, and by implication DOC, have no clear meaning to consumers, and so potentially could mislead without a clear qualification of the full Doctor of Chiropractic courtesy title. So if you're going to use the doctor title, we therefore recommend that the best course of action is to include the courtesy title in full. So for example, doctor name, Doctor of Chiropractic. Otherwise, you're going to have to immediately qualify a DC or DOC phrase, which could kind of potentially look a bit messy within advertising.
I see. And is that all?
No, even if an ad makes clear that the qualification held was Doctor of Chiropractic, as in the full courtesy title, you're still going to potentially have an issue with the fact that consumers are still going to assume that this is a type of general medical qualification. This is kind of partly because the word doctor is so loaded with meaning, and consumer assumption is that even if the full courtesy title is used, there still might need to be some further qualification.
What kind of qualification?
We recommend using a clear statement to explain that it's a courtesy title and that you do not hold a general medical qualification. We understand this can look clunky and that you might feel that it kind of undermines the title, but again, you have to remember that our concern is how consumers will interpret the title in an ad, and as we've already discussed, they're likely to have a very clear understanding of what doctor means, especially in the context of a service that's kind of in relation to health.
Okay, so do you have a similar position on chiropractors who reference specialisms they may have, like a pediatric chiropractor or someone who uses specific techniques?
From a CAP perspective, we kind of don't see any immediate issue with referencing specialisms, as long as you can demonstrate that this specialism is held. But it might be still worth speaking to the GCC to see if they hold a position on like any minimum training or minimum qualifications in order to basically make a claim that you have a particular chiropractic specialism. The only thing we recommend thinking about here is making sure that you avoid making kind of any inadvertent claims on the efficacy of a type of treatment for a type of condition if you don't hold evidence that this technique is efficacious. For example, a reference to something like I spent sort of years studying a postgraduate MSc in chiropractic pediatrics is likely to be acceptable. But a claim, something like I specialise in scoliosis, is likely to be seen as a claim that chiropractic technique is particularly efficacious in treatment of childhood scoliosis, which would trigger the need to hold evidence to demonstrate this. So it doesn't necessarily mean it's a problem, but it just triggers the need to hold evidence. And this is coming back to Rule 12.1 again. We think kind of the least risk would come from a kind of course name itself, but there is a risk that such a name could also imply efficacy. So just literally saying MSc in McTimoney and whiplash could be seen as a claim that McTimoney technique is efficacious in treating whiplash. So again, it's something to be careful about. It doesn't automatically mean that quoting the course name is a problem, but again, it's just being wary of the fact that the ASA might ask you for evidence to demonstrate that the technique referenced, the qualification you hold, has been shown to be efficacious.
McTimoney is a hard thing to say.
Very hard.
Some chiropractors have asked about whether testimonials are caught by these rules, especially given that they're made by customers themselves, and so the chiropractor may not necessarily have control over them.
Yeah, there are a couple of rules in the code when it comes to testimonials, and these apply to everybody. So we've talked earlier about the fact that kind of chiropractors are not singled out. We appreciate that, of course, you can't control what people are going to say about the service they received, especially if they want to wax lyrical about a very positive personal experience. And at the end of the day, that's what it is. A testimonial is a reference to a personal experience. However, you can control whether or not you're going to incorporate that testimonial into your advertising. And this is a decision that's best taken on a case-to-case basis. But I mean, looking at the rules themselves, in the first instance, you're going to need to make sure that you hold evidence to demonstrate that the testimonial you're using is genuine and you have permission to use it, and that you hold the appropriate contact details for the person who made it. These rules are kind of pretty much in place simply to kind of prevent advertisers from creating a positive impression of their product or service by passing off their own content as a testimonial, as something from a member of the public. It might be good practice to obtain this information, so the sort of permission to use it and the contact details, etc., when you actually initially invite customers to make a testimonial. This is probably just much easier than kind of obtaining it retrospectively if you suddenly decide to use it in your advertising. Looking at the content of testimonials themselves, there is a particular rule in this area, and it's basically that testimonials that contain factual claims need not to be misleading. And as we've kind of talked about earlier, this idea of the fact that ads can be misleading if factual claims aren't supported by evidence. And in this case, we know essentially we're talking about efficacy. So it's already been established that chiropractic techniques are efficacious in some areas. So testimonials that kind of refer to those accepted areas or kind of talk about a kind of very subjective experience are likely to be acceptable. And here are a couple of examples of the sort of things that we would look at and think are likely to be acceptable without the ASA asking for additional evidence to support any factual claims. This position changes slightly where the testimonial is likely to be seen as an objective claim about the treatment received and references a medical condition that isn't currently on the list. We talked earlier about this kind of a technical approved list of claims, the things we've already seen evidence for and accept. This doesn't necessarily mean that these claims are a problem. It just means that it triggers the need for you to hold evidence. So again, looking at the examples on the screen, they all reference conditions like car accidents, that's a kind of implied reference to whiplash potentially, a reference to babies crying. These are all things we haven't yet seen evidence for. So it's likely to trigger the need for you to hold evidence that the chiropractic techniques that you're going to be using have shown to be efficacious in treating those particular named conditions. Like I said, that doesn't necessarily mean it's a problem. And this position isn't because there's doubt over whether an individual is telling the truth about their personal experience. It's simply because consumers are likely to view that testimonial as a claim that the therapy can help them. It's all just a matter of being careful about which testimonials you're using. If you're not sure you hold evidence to support a treatment claim and you're not sure that the evidence is good enough, then it might just be best to not use that particular testimonial and go and find another one that you can use with confidence.
Okay, great. Well, that was a bit of a kind of whistle-stop tour, but that is all we have time for today. So I'd like to thank everyone for joining us, and thank you, Janet, for sharing your pearls of wisdom. It's been really interesting and I'm sure very helpful to our audience. As I said at the head of the webinar, if people do want to submit any questions or comments, please do. As for this kind of recording, we'll be posting a recording of this webinar onto the CAP YouTube channel in the coming days. So if there's anything you'd like to refer back to, please check it out there. We do, of course, have a wealth of resources available on our website. Just head to asa.org.uk and search chiropractic. And if you'd like specific feedback on any ads that you're putting together, whether they're ready to publish or just in the conceptual stages, CAP offers a free copy advice service via the website too. Make sure to follow us on LinkedIn and Twitter if you want to keep up to date with our latest advice and guidance or submit any questions to us. And finally, thanks again for joining us. We hope you found it useful. Until next time, goodbye.